Vollin Holdings Ltd.
Mr. Gletcher.
Good morning, my lord. I have overnight again done some substantial pruning in the earnest hope of finishing by my 11:45 cut-off.
I'm afraid we are going to hold you to that.
Yep.
So one way or another, judicial interventions notwithstanding, you have to finish by 11:45.
I understand. So as part of that streamlining process, the first thing to draw your attention to is you should have on your bench each a note. And what we've done there is to identify from yesterday's transcripts the various questions which were raised by the members of the panel, and we've given some answers to those questions, I hope fairly succinctly. The only thing which requires any explanation at all, if you turn over to the first substantive page.
Section 17.
Yes, and we've set out the material provisions there. So the bottom line, and I should frankly confess this was not a point which was discussed with the judge, it got lost in the fog of the multiplicity of allegations and issues. It is, we were wrong to proceed on the basis of first instance that the shareholders agreement is part of the Constitution, but as you indicated yesterday, it has a relatively limited significance because it goes simply to the question of breach of the provision in Part 10 of the Companies Act of the director's duties to adhere to the Constitution.
Yeah.
But with that point aside, when we left yesterday evening, we were looking at finding number 2, which is unfair process in relation to the removal of Sachs. I showed you yesterday Yamseng and Mr. Justice Coulson's decision in Costain in support of the proposition that Mr. Justice Johnson was wrong in this case to suggest that good faith entails some generalised duty of disclosure or open pleading. I submitted to you that the principle is much more limited, that the duty is one of honesty. And specifically in this context, what that means is that if in a contractual context, you lead your counterparty to understand the ground rules are one thing, if those ground rules later change to your knowledge, you may come under an obligation to disabuse your counterparty of its misapprehension. We say that is the limit of what you find in Yamseng and Costain. Now, on that point, the court has seen that Mr. Justice Johnson below relied heavily on Judge Klein's analysis in Unwin. If you look at Judge Klein's analysis in Unwin, you find that he relied on the decision of Mr. Justice Sales in a monumental 400-page decision called Barthélemy. And within Barthélemy, Mr. Justice Sales relied heavily in turn on an Australian case called Macquarie. So Macquarie is in a sense the fountainhead. I'm going to take a little time taking the court to that. The court will find that in volume 4 of the...
So is this going back on yourself, just so I'm in your schedule, your table?
Yes.
You're going back on yourself?
Forgive me, no. I'm still in the section in my roadmap dealing with issue 2. I've dealt with 2 authorities and I'm now dealing with one we haven't looked at.
I see.
I'm sorry if that wasn't clear.
No, my fault. Thank you.
So volume 4 of the authorities bundle, tab 22, and within that you find Macquarie, and if you go straight on, you can see it's a long judgment, and we can dive straight into bundle page 1181, which it starts at 1180, and we pick it up on 1180. You can see starting at paragraph 146, there is a citation from a distinguished Australian former judge, Sir Anthony Mason, summarising certain principles in relation to the contractual duty of good faith. Then over the page at paragraph 147, you can see that the New South Wales Court of Appeal says at 147, a contractual obligation of good faith doesn't require a party to act in the interest of the other party or to subordinate its own legitimate interest to the other party, although it does require it to have due regard to the legitimate interests of both parties. And that passage is replicated in Judge Klein's decision in bold, so it's a passage upon which he particularly founded. But we respectfully suggest to the court that in all of these good faith cases, and none more so than in this one, it is absolutely critical to understand the factual background, what the issue actually was for determination, rather than simply relying on statements of broad principle deprived of their contextual context. So the facts of this case are, I regret, quite hard work to fill it out of the decision, but I'm going to endeavour to assist the court by setting them out to help you if you come back to this in the course of preparing judgment. They were as follows. In 1989, the claimant, that's Macquarie, entered into a long-term joint venture agreement with the Defendant Health Authority in relation to a site owned by the defendant. The site already had on it a public hospital on one part of it, and the idea was that the claimant Macquarie was going to develop a private hospital on another part of it. Fundamental to Macquarie's decision to commit to that joint venture was an understanding that when the development was complete, the overall site would operate as a coherent whole with good pedestrian links between the two hospitals. When you read the judgment, you'll see that is referred to as the, quote, campus concept, quote unquote. And that understanding was reflected both in oral exchanges before the contract was signed and in the agreement and recitals in the contract itself. I won't take you to them, but for your note, you can get both of those points on bundle page 1180, and the material passages of paragraph 141 for the oral assurances and 144 for the contractual references. 1994, however, so this is 5 years into the life of this joint venture, planning permission for the redevelopment as a whole was in doubt, as the result of which the defendant, the health authority, decided to protect itself by developing proposals for its own portion of the site which abandoned that fundamental campus concept. Again, I won't take you to the passage in the judgment, but for your note, it's paragraphs 107 to 108 on bundle page 1116. And that obviously represented a major change of tack, but the Defendant Health Authority told Macquarie nothing about its new approach, and Macquarie only first learned of it when the defendant made a formal planning application on that different basis 3 years later in January 1998. And that's paragraphs 125 and 126. The parties' agreement, there were a number of them, but the relevant one was contained in what you can find on bundle page 1142, and it contained a good faith clause. Shall I just show you that, in fact? On bundle page 1142, so you can see the clause in issue. There are a number of different agreements, but if you look towards the bottom of 1142, you can see a clause 15.4. That was the material one for this purpose. And so the question that fact pattern raised for decision by the Court of Appeal was whether the Defendant Health Authority had breached that obligation of good faith by failing to tell Macquarie promptly, back in 1994, that it had had a fundamental change of heart about the campus concept. So that was the question actually for decision. And if we now go back to where we started on bundle page 1181, Judge Klein, whose reasoning Mr. Justice Johnson adopted, as I've indicated, emphasised 147. But if you look at 148, you can see quite how specific the point is that's being decided. Picking it up in the third line, the judge says that in my opinion, when area health planning processes would make a substantial difference to what Macquarie could reasonably expect regarding the flow of persons between the hospitals or the creation of a campus concept, the obligation of utmost good faith would require that Macquarie be informed of this, at least so as to enable them to take into account of it in the design and construction of the works contemplated. So that was the extent of the decision, and that was a breach of what I'm calling the autonomous duty of good faith, because it wasn't honest in the extended commercial sense discussed by Mr. Justice Leggett. What it was emphatically not, in my respectful submission, was a finding that an obligation of good faith somehow entails obligations of disclosure which can't otherwise be justified on ordinary principles of construction. So that's the authorities in relation to good faith and disclosure generally. And having dealt with that, I'm now going to take you to the judge's decision and show you the material discussion of this issue, which starts in tab 8 of the core bundle at page 170.
Just before you do, without wishing to take time on it, you say that F&C is explained on a similar basis.
Yes, I do.
Yeah.
And if Mr. Hollington wishes to say differently, I may have to deal with that in reply, but I just would like to flag this point if I may. F&C is an enormously long case, and when you look at the official report, it omits much of Mr. Justice Sale's findings of fact. And we have actually put in some passages which will cast light on that, and we'll have to go to them if there's an issue about it.
Yeah.
But in broad summary, we say that's pretty much the same place that Mr. Justice Sale's come out.
Yeah.
Back in Mr. Justice Johnson's decision, full bundle tab 8, page 170, and the court will recall that he made 3 subsidiary findings in reaching this determination that Dr. Sachs had been removed in a procedurally unfair way. The first is one you see at paragraph 406, and I'm going to come back to that at the end, but I want to start with the other 2 if I may. So the second one is the one that you see starting at paragraph 407. And it runs over the whole of the next page, all the way down to paragraph 412, bottom of bundle page 7. And you'll have pre-read this, so just to remind you, the judge's point here was that at the last meeting with Dr. Sachs on Monday, the 14th of March 2016, the investors, or one of the investors, had already decided to make funding available for a limited period to keep the company afloat until the end of May. The judge's point here was that the investors were under a duty to disclose that information to him. And the judge made the point that if that disclosure had been made, Dr. Sachs wouldn't have gone away from the meeting on the Monday as he did, having misunderstood a representation made by Mr. Fletcher, under the misapprehension that we were about to pull funding immediately. And the gist of that, the court can see in paragraphs 411 and 412 on page 171, where the judge says at 411, I don't go so far as to say that Sachs was deliberately misled. It's not necessary for me to do so. I'd like you just to underline those words. I say only that the information given to him was ambiguous, and he acted reasonably, in my view, by interpreting what he was told as including the risk of an immediate and peremptory withdrawal of funding. That created a degree of urgency, which meant Mr. Sachs felt he had no room for manoeuvre. 412, in short, it seems to me that dealing fairly and openly with Dr. Sachs required him to be told clearly of Vollin's decision already made on Saturday to provide funding to the end of May, and that didn't happen. So that's the guts of the decision on that one. Now, we unhesitatingly accept that if his lordship had found that we either deliberately misled Dr. Sachs or that Dr. Sachs misunderstood the position and we knew that, but failed to act on it to correct his misapprehension, that on the strength of the authorities I've shown the court, that would likely suffice for a finding of a breach of duty of good faith. But all the judge in fact found was an ambiguous statement made by Mr. Fletcher. And consistently with the authorities, we say that involved no such breach of duty. Now, in his skeleton argument, I'm not going to turn it up, but it's paragraph 35, core bundle, tab 4. Mr. Hollington prays in aid 2 provisions of the Shareholders Agreement in this context, which, although the judge didn't himself rely on, he says supports the conclusion which the judge came to. And if you keep the judgment open, because we'll come back to that, but if we now look at the Shareholders Agreement in the other volume of the core bundle at tab 20, And within that, the material page is page 544. Two clauses Mr. Hollington refers to in his skeleton argument, a clause 5.2. And just pausing there, we looked at that yesterday afternoon, and I made the submission in a different context that really has nothing to do with it because it's to do with the conduct of the business as a defined term. So leave that to one side. Mr. Hollington's second point then turns on a provision of 5.3 that we haven't yet looked at. 5.3 starts on 544. Without prejudice to the foregoing provisions of this clause, the shareholders agree that the company will be run in accordance with the following general principles. And then over the page at F, the company in each CPG group company shall keep the shareholders, except the B shareholders, fully informed as to their material, financial and business affairs. So that is an obligation on the company to keep the shareholders informed. It has nothing to do with the question of whether the investors had an obligation to tell the minority shareholders how they propose to use their own money or not. And I make the obvious point that in the context of an elaborate, carefully, professionally drafted agreement, the imposition of this circumscribed obligation to inform on the company without any corresponding obligation on the individual shareholders is radically inconsistent, I respectfully submit, with the judge's conclusion that such an obligation to disclose can be construed out of clause 4.2 out of the duty of good faith. That takes me then to the next of the judge's three process points. And in light of what I've already submitted, I'm going to take this pretty briefly. Back in the judgment, we're now on bundle page, or bundle page 172. And Mr. Justice Johnson's second process point is the one you see from paragraphs 413 to 415. I will just read a few extracts. Finally, under this heading, I also think there was a failure by the investors to take into account the interests of the petitioners as well as their own interests. At 414, he says, starting in the third line, by March 16, the investors have reached the view that success was possible only with Dr. Sachs out of the picture, viewed purely commercially. I have no doubt that that was a rational view to have come to. 415, all of that has to be weighed against the fact that from the point of view of the minorities, Dr. Sachs was the jockey they were backing. It was his vision and leadership they had invested in. And then at 415, at the final sentence, you see, I've seen nothing to suggest that the investors took account of any of these factors in deciding how to deal with Dr. Sachs in March 2016. It was not suggested that they did. And I've already made the point to the court that the duty of good faith simply does not oblige one party to, quote, take into account the interests, unquote, of the other party in the entirely general sense suggested by the judge in that paragraph. And that may be a sufficient answer to this point. But I did also make the point in my skeleton, and I'll elaborate on it briefly, that it is impossible with respect to see what the judge's supposed process duty actually bites on. There are two possibilities. Either the judge was correct in his finding one, in determining that the investors couldn't properly remove Dr. Sachs at a general meeting at all. If that's right, no issue arises about consulting the minorities for their views. Alternatively, the judge's finding one is, as we submit, incorrect, and the investors could vote Dr. Sachs out at a general meeting. In which case, as we said in our skeleton, how were they supposed to have regard to the interests of the minorities, quote unquote, other than by convening a meeting and putting it to a vote? Had they done so, of course, very much alive to the point that they would inevitably have prevailed, because by this point they had a shareholding of 93%. That then leaves the third and final of the judge's three process points. That's back on core bundle page 170.
So can we just have a quick look at paragraph 416?
Yes.
As I understand it, what the judge is saying is that in that paragraph that he finds that the investors legitimately held the view that Dr. Sachs and his vision, as he put it, were a busted flush.
Yes.
But then he says that in taking the action they did, they failed to have regard to two facts, that there's at least scope for a different view, and excluding Dr. Sachs would materially disadvantage the minorities in terms of the balance of power. And then what he says is, it doesn't matter that the vision of the majority, i.e. the investors, might have been a sound one as to what had to happen to the company commercially. But the point is that good or bad is an expression of the will of the majority only. And then he comes back to the point that the 2013 Constitution was expressly designed to avoid the will of the majority. What I'm just trying to unpick in my own mind is the extent to which this reasoning depends or doesn't depend upon his view of the interpretation of the Constitution, as he puts it, arrived at in 2013. I mean, you haven't, as it were, can you try and assist me to
Yes.
understand how you would say that the judge, which bits of that do you accept the judge got right, do you rely upon, and which bits do you say he got wrong in?
Let me, if I may, I think there are two different points here. And let me say what they are, and then you'll ask me if I haven't engaged with your question. So what the judge is doing at this stage of the exercise is just to say that clause 4.2 mandates a general obligation of fair and open dealing. So to that extent, this aspect of his reasoning has nothing to do with his views in relation to the constitutional setting. The second point to make in response to your lordship's question is that there is an oddity in this paragraph in any event. Because to the extent the question was, could Dr. Sachs be sacked as an employee? What the Constitution contemplated was that he would be sacked by board majority resolution. And as your lordships know, because I've already made this point, in fact, what ultimately happened was that there was a unanimous board resolution signed by all 6 directors, including Dr. Sachs and Mr. Faulkner. So to the extent the judge is saying that there's been a unilateral imposition of majority will, we respectfully suggest that to that extent it is also not an entirely accurate summary of his earlier findings. What I think he's saying is what you've done is you've used the threat of passing a vote at a general meeting.
Yes, I mean, you just focused for a moment there on the employment aspect. I think he's focusing more on the removal of Dr. Sachs as a director, isn't he?
Yes, subject to, I mean, to an extent, for the reasons you've seen looking at his service agreement, to the extent one follows the other, because the service agreement specifically says if he's removed as an employee, he may be removed by a majority vote at a general meeting. I'm summarising very broadly, but I showed your lordship that provision yesterday. So what he appears to be saying is that it wasn't proper to use that majority vote to remove Dr. Sachs at all. So forgive me, that's a rather long-winded answer to your lordship's question. I think when you unpick it, buried in that paragraph, there is also an assumption that it was improper to remove him at all.
Yes, I mean, he starts off, as I read this, he starts off by dealing with the question. It's not so much about, as you put it, open and fair dealing. It's a question, as he puts it at 413, of a failure to take into account the interests of the petitioners. That's start at 413, and then the core of 416 appears to be a finding that even if they genuinely believe that this is what had to happen in the interests of the company, the investors failed to have regard to the contrary interests, or at least the interests of Dr. Sachs.
Yeah.
But then he moves to the point and arrives at a point where he appears to suggest that they just couldn't do it anyway.
Yes.
So in other words, he's not just looking at the question of failure to consider somebody's interests. He actually arrives at an answer that says, but they couldn't do it anyway. And I'm not sure I can join the dots.
Yes, I think your lordship is right. I think embedded within that 416 is the proposition. It's effectively the proposition that underpins finding 1 as well, which is even in general meeting by a vote, we could not have got rid of Dr. Sachs, from which it follows that the threat to do so was also legitimate.
I mean, developing the same point. If there's an obligation to have regard to the interests, and you think subjectively that the only way this company is going to go anywhere is by removing Dr. Sachs, on the face of it, in forming that conclusion, you will have taken account of the interests of the shareholders as a class.
Precisely.
Including the minorities.
Yes.
And I'm not sure there's any finding by the judge that that wasn't done, that there was any sense that in forming your view that it was in the interests of the company, you hadn't taken account of some separate financial interest of members in that sense. So as you say, what the judge actually finds is that, well, not merely had you not had regard to whether or not the position of Dr. Sachs had to be maintained, but that you as my lord said, you couldn't override that.
I would accept that. Well, given time, can I
Yes.
take you to the third of the findings of process breach, which the judge found back at bundle 170, paragraphs 405 and 406. And 405 is important because you can see in that the test which the judge is bringing to bear. I'd go further and say that the process by which Dr. Sachs's removal was achieved involved a breach of the good faith duty. In my judgment, there was a failure to deal fairly and openly with Dr. Sachs. And then at 406, he develops that as to the failure to deal fairly and openly, it is obvious that the meeting on 14 March 2016 was set up to take Dr. Sachs by surprise. And then picking it up 5 lines from the bottom. All the same, Dr. Sachs wasn't expecting at the meeting on Monday to be presented with an ultimatum that he resigned from the business he had founded and which he still believed might deliver his vision. Mr. Fletcher's email to him confirming the meeting gave no indication of what was in store. He was taken by surprise, and deliberately so. So, the test he's applying there, as I emphasised in reading 405, is that we were obliged to deal fairly and openly. We say that is the wrong test. More than that, it may not be necessary to say a great deal, but I will show you very quickly an authority which his lordship relied on, which was also cited by Judge Unwin in Judge Klein in Unwin, which is a decision of Mr. Justice Neuberger's when still at first instance in a case called Mullins. And the court has that at volume 5 of the authorities bundle. I'm going to take this very quickly to try to keep on track. It's tab 28. In a nutshell, what this was about was a firm of insolvency practitioners. One of the members had been expelled. There was an issue about whether the contract of partnership had been terminated by repudiatory breach. And in the alternative, he sought a determination that there be a judicial dissolution. All of that's merely by way of background. There are 2 things that I would ask the court to get out of this. The first is at bundle page 1399. No, sorry, wrong reference. 1409. The reason that this was particularly relied upon by Mr. Justice Johnson is that there was a meeting here and it was common ground that the parting partner had basically been bushwhacked. And in the context of that, you see Mr. Justice Newberger's discussion of the principle at paragraph 95. And just to be clear, he's talking here about the context of good faith in equity between partners, not a contractual duty. And if I could just invite you to cast your eye over paragraph 95.
Sorry, 95.
Yes, please. Just between letters D and E.
Yes, yes.
It's the whole of that paragraph. And the passage I'm particularly relying on is, out of the 3 points his lordship makes, it's his second point, just above letter G. Secondly, at least in general, a partner need not be given an opportunity to explain his conduct or to argue his corner before he is expelled. So the trial judge in this case, in the case before your lordships, before this court, the view that this case was authority for the proposition that you can't take somebody by surprise, you can't railroad them to expelling them. In fact, the point that Mr. Justice Newberger makes as a matter of principle is that there is nothing implicit in the obligation of good faith to require a partner to be given an opportunity to explain or defend himself. And what actually sprang the decision in this case, you see if you now turn back to page 1399, there are actually a number of different points where Mr. Justice Newberger, in fact, makes findings of conscious impropriety. Given time constraints, I just invite you to mark paragraph 57, and I'll just highlight the two key ones which are in here. The first one is at letter C. We see Mr. Travers referred. Mr. Travers was one of the remaining partners who had been responsible for the expulsion. And Mr. Justice Newberger says Mr. Travers referred to a without prejudice meeting in his witness statement. I'm satisfied he did this knowing that he ought not to, but with the aim, as he saw it, of improving the defendant's case. And then more seriously, beneath D, you'll find that what Mr. Travers did was actually to write a letter to the expelled partner of bankers to try to put him under financial pressure. Just beneath D, I believe this letter was written for the purpose of drawing to the attention of Mullen's bankers the fact that he may be in financial difficulties, thereby seeking to put pressure to settle on Mullins. The service of a statutory demand, bearing in mind that Mullins was an insolvency practitioner, being legally advised and represented, strikes me as an unattractive way to behave, to put it at its lowest. So, in our submission to this court, far from supporting some generalised principle of fair and open dealing, connoting that one can't take one's counterparty by surprise, as Mr. Justice Johnson thought, this case is entirely consistent with our analysis, which is that a finding of breach of the autonomous duty of good faith requires of dishonest or bad faith conduct.
Sorry, repeat. Finding a breach involves dishonesty or bad faith.
Dishonesty or bad faith.
But did those matters feed into paragraph 100?
Yes. What in fact happens is that the judge in this case concludes there's a point of law about whether the partnership agreement can be determined by repudiatory breach, and the judge determines that as a matter of law it can't. He then goes on to consider the question in the alternative against the possibility of an appeal. And I haven't recently refreshed my recollection of the decision, but my recollection is that his finding of repudiatory breach is based upon what he considers to have been a breach of the obligation of good faith on the strength of those matters.
If you look at paragraph 100, he says, over and above this, the conduct of the meeting did not, to my mind, comply with the duty of good faith, blah, 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 blah. I consider that the way in which Mr. Mullins was bounced, both into and at the meeting, was outside the comparatively wide range of acceptable behaviour. He was not only set up in terms of attending the meeting without any significant warning, but the conduct of the meeting similarly involved a setup. So he's not here relying on the paragraph 57 matters.
No, he's not. And because I've rather compressed what I'm saying about this, I haven't given you an entirely full account of the relevant findings. If
Well,
you look
I
at
mean,
that
to be clear, I mean, paragraph 57, in fact, is simply a paragraph which is the basis, or one of the bases for him rejecting the account given of what happened at the meeting by the other partners, which is set out at paragraph 55. I mean, at 55, the judge says there are reasons for doubting the accuracy of the evidence of Lawton, Travers and Clements in connection with the meeting. They denied that it was all planned to bounce Mr. Mullins into resigning, etc., etc. And then on the issue of credibility, i.e. as to that evidence, the judge deals with some things in paragraph 56 and then further 57, furthermore,
yes.
etc. So, I mean, the bad behaviour that you referred to in paragraph 57 is actually reasons for the judge saying, I don't accept their account as to the meeting. And in fact, as my lord has just pointed out, the judge did go on to say what happened here was that Mr. Mullins was bounced. He was, to use your expression, I'm not sure I understand precisely what it means, but he was bushwhacked or whatever at the meeting.
So, as I've indicated, having pared it back, I haven't given court as full a description of the factual background. When you look at it, you'll see that Mr. Justice Newberger refers to Mr. Mullins having been bullied. And what actually happened was that the meeting was convened. The day before the meeting, the locks of the office were changed so that Mr. Mullins couldn't get in. And it was the case on behalf of the expelling partners that he had agreed to resign during the course of this meeting. And they then sought, as Mr. Justice Newberger goes on to find, to foist on him a whole load of insolvency files they didn't want to retain by couriering them to his home. So there's quite an extended course of dealing. As we say in our skeleton argument, if you look at the fact pattern of what happened here, Dr. Sachs is asked to resign on the 14th of March, goes off, takes legal advice for which the company pays, resigns on the 21st, and on that date executes a board resolution sanctioning his own compromise agreement and severance. We respectfully submit that this case, Mullins, is a world away from the fact pattern of what happened.
At the end of paragraph 100, the judge, Mr. Justice Newberger, said, bullying, seeking to trap and intentionally taking by surprise with a view to shock in the hope of obtaining an advantage for the co-partners and a disadvantage for the partner concerned must, in my view, amount to a breach of good faith.
Yes.
Where do I find in the judgment what he meant by the fact that this wasn't just being done, as it were, to achieve a result, i.e. expulsion, but actually was designed to achieve personal benefit?
So I may not be able to lay my finger on the passage in the judgment, but what's being referred to is this. There's a provision in the partnership deed that if one of the partners leaves, agrees to go, the remaining partners can effectively put certain files onto that partner and credit the partnership account with a determination of how much they are worth. And so what effectively happened here was not simply that the appellant Mullins was expelled, but it was being said by the respondents who had agreed to go at a meeting that as a result of that, they were entitled to make a final and determinative conclusion as to how much he owed in respect of a whole load of files they'd forced on him that they didn't want. You can see, I'm afraid I haven't marked it up for the purpose of taking the court to it, but you can see some reference to that issue if you turn back to bundle page 1397. And you can see there that there is, in paragraph 48, there are references to the work in progress value of the files which they claimed they could debit to Mr. Mullins' account. So the vice here was not simply in removing him, it was in purportedly having removed him at a meeting with no notice, having changed the locks, and then that removal triggering further highly adverse financial consequences for the departing partner, Mr. Mullins.
I mean, might this be the real issue? I think you sort of accept that the obligation of good faith carries with it an obligation not to act in a commercially immoral way. On the facts, Mr. Justice Neuberger concluded that there had been bullying, seeking to trap and intentionally taking by surprise with a view to shock, blah, blah, blah. That's consistent with the expelling partners having acted in a commercially immoral way. You say, well, this is different because what happened on the 14th was that you told Dr. Sachs that you weren't going to go on funding and that he would be removed if he didn't resign. Yeah, so be it, that was the position.
Yes, I mean, sure, it came as a surprise, but when the news was initially broken, inevitably at some point that news will have been a surprise when it was first broached. And the difference, as I've indicated, is the writing plainly is on the wall, plainly at the point at which the investors say that with a 93% shareholding, appreciates he's going to go. The question may then be whether he goes consensually or, like Mr. Faulkner, chooses to fight it at a shareholder meeting. And what he actually does is to take legal advice, elects not to fight it, and as I've indicated, then affects the board resolution sanctioning his own departure. That takes me to the next and the final topic on the appeal in that list of 12 findings that I took the court to yesterday. There are 2 remaining findings that I haven't addressed you on, which findings number 5 and 6, concerning Mr. Faulkner's role in the business in the 7-month period from Dr. Sachs's resignation until Mr. Faulkner's own expulsion. The court knows that originally in our grounds of appeal we took a procedural point about whether this had been pleaded in the way in which the judge sustained it. And prior to the first case management conference in February, we indicated that we would no longer pursue that. So I'm addressing this now purely as a point about substantive error. Going back into you can put the relevant volume of the authorities bundle away and now go back into the judgment, back in tab 8. The relevant page here is page 176. And I do need to take you a little detail through how he did this. The material passage starts over the page 177. Now, in our skeleton argument, we made the point that if you examined how this had been pleaded, it had been pleaded this 7-month period, the failings that were identified were failings to provide information. And Mr. Justice Johnson at paragraphs 435, Roman 1 through 3, summarises those, and I'll read them very quickly, adding in some numbering so you can see what the 6 individual complaints were. So last line of 435, these included the following main points as which specific complaint is made. The withholding of information from Faulkner and the minorities in particular as regards 1, the group's funding requirements, 2, the investors' intentions in relation to funding, and 3, the decisions to dispose of Newton Aycliffe, and 4, to serve the last time buy notice on sellings. Thereafter, 5, the withholding of information from Faulkner in relation to the ongoing negotiations for disposal, and then skipping down to 3, 6, the failure properly to consult as regards the $4.5 million share subscription made by Vollin in August 2016. So if you then turn on to page 178, you can see how the judge starts his discussion of this issue at paras 439, 440. 439, as regards the early period after Sachs's departure, the emphasis in the petitioner's case is on the withholding of information from Mr. Faulkner and the minorities about a number of important matters. Just summarise them. 440, it seems to me that this emphasis on a failure to provide information and consult slightly obscures the true nature of the petitioner's complaint. That is not so much about a failure to provide information as about a lack of any real involvement at all in the management of CPGL. And that is the basis upon which His Lordship then goes on to uphold the petitioner's complaint about governance in this 7-month period. And you see that if you turn on to page 181 and looking at paragraph 456, just by the first hole punch, he made reference again to the 6 individual heads of complaint about information I've outlined to you, and he says, pausing there, it seems to me that the matters of complaint identified above, I've just shown you that, are all best characterised as examples of greater or lesser severity of the more general problem of CPGL's constitutional machinery having broken down. And then running between 457 and 459, he discusses the 6 allegations of failing to keep Mr. Faulkner informed. And I'm not going to go through them in any detail, but I'm going to say that when you read that, you'll see that all of them fail on the facts, bar one, which is the point that, as we freely accepted, the investors concealed from Mr. Faulkner the early stage discussions they had with Carr about the disposal of the Newton Aycliffe site. But even on that, if you look at paragraph 459 at the bottom of the page, even that the judge recasts as a complaint about really being about the breakdown of the constitutional machinery. He says the deception of Faulkner as regards Kayam is a more serious matter, of course, but ultimately, in my view, symptomatic of the same basic problem. And you see an interesting example of that basic problem, as the judge terms it. If you look at the preceding paragraph 458, reading it for the first line, he says the same goes for the company's fundraising efforts in August, picking it up in the 5th line. Given their consent was sought and provided, it's impossible for them, that's the minorities, to say they didn't know what was going on or were not consulted. But what they can say is that by this stage, the proper constitutional machinery for approving new subscriptions had entirely broken down. Even assuming Phil Fisher's view of clause 20.1, I'll come back to that in a moment, was the correct one, what it contemplated was a board constituted and operating in accordance with the 2013 Constitution. Self-evidently, by August 16, that was no longer happening, thus whatever they may have known, the crux of the matter is that the minorities were deprived of the benefits of the constitutional settlement they had agreed with the investors. So the judge's point there is that the petitioners are unfairly prejudiced because forgive me, I've jumped ahead. Now the point that the judge is discussing there is the petitioner's complaint pleaded originally at paragraph 70.3 of their petition that they were unfairly prejudiced because they weren't consulted in relation to a proposal in August 2016 that the investors agree with the company a $4.5 million subscription for new shares. And our answer at trial to that allegation of non-disclosure was that it was manifestly wrong for a reason that I can show you if you turn back in the bundle, keeping a finger in on page 181, to bundle page 136. What actually happened in relation to this £4.5 million equity subscription? You can see from paragraphs 252 to 255. So 252, without warning, forgive me again, to set the scene, CPGL solicitors who were Field Fisher originally proposed that this subscription be approved by means of a CPGL board resolution. So they were proposing there be a board resolution to agree this $4.5 million equity subscription. But Mr. Faulkner insisted that a provision in the Shareholders Agreement, clause 20.1, which I don't need to show you, required a members' resolution approved by the votes of the minority shareholders only. And if you look at paragraph 252, you can see how that panned out. So the judge says, instead, without warning, Mr. Faulkner took it upon himself on the 17th of August to circulate the minorities with a form of written resolution to have them approve the proposed subscription agreement. The covering letter appeared to come from the board of CPGL, but of course had not come from the board and was against the advice of the company's solicitors, Field Fisher. And we made the point at trial that that circular sent surreptitiously without the prior consent or approval of the board was a gross breach of duty. And if you look briefly at paragraph 255, you can see the judge records the evidence that he had about the decision to remove Mr. Faulkner. 255, halfway through, when asked about the decision finally made to remove Mr. Faulkner as director, Mr. Bulgar recalled that the decision was taken about 5 minutes after we received the email he sent to the minority investors, purporting to come from the board. So the petitioner's originally pleaded complaint was about failure to consult the minorities about an equity subscription. But if you now look at paragraph 254, you can see it says, Field Fisher canvassed an alternative structure, but Mr. Faulkner pressed ahead with collecting the signatures from all the individual minority individual investors before giving his approval as director to the Vollin subscription. That exercise was eventually concluded only by lunchtime on Wednesday the 24th, shortly before the payroll deadline. So turning back to where we started, if you've still got a finger in page 181, the petitioner's pleaded complaint is about a failure to consult the minorities about this equity subscription. And we made the submission of the trial to the judge that was nonsense, because it was about as clear as it possibly could be that not only had the minorities been consulted, but they actually approved it. But then if you look at the judge's reasoning on page 181, despite that fact, as I've shown you, he still goes on to say this represented a violation of the constitutional settlement, as it appears because it wasn't taken at a board meeting constituted and operating in accordance with the 2013 Constitution, by which he evidently meant a board with Dr. Sachs on it. And he concludes that the minorities were as a result prejudiced by how this was dealt with, even though firstly it was Mr. Faulkner who insisted this be dealt with by way of shareholder resolution rather than board resolution. And even though the minorities in fact passed that board resolution which Mr. Faulkner circulated. Now, on one view, it's enough to dispose of finding 5 for me to say that, like everything else bar finding 2, it turns on what we say is the erroneous view which his lordship formed about the constitutional structure or the constitutional settlement, and you can see those words used both in the third from bottom line of paragraph 457 and in the third from bottom line of paragraph 458. But we do go further than that in our skeleton. I wanted to develop the additional reasons we gave there in support of the proposition that the judge's reasoning to his finding 5 was unsound. The starting point for discussion is the company's articles, which were in modified 1985 Table A form. Table A is in Volume 7 of the Authorities Bundle, tab 62, and within that there are 2 very familiar provisions that I want to highlight. And I should just say, by way of preface, neither of these are affected by the bespoke modifications that were adopted. So these are both part of the Constitution. So the first of the 2 provisions is the one you find on bundle page 2413. It's Regulation 70, under the heading Powers of Directors. Subject to the provisions of the Act, the memorandum and the articles, any directions given by special resolution, the business of the company shall be managed by the directors. The important words for my purposes are any directions given by special resolution. So the judge was entitled to say, as he did in his judgment, that the business was prima facie to be managed by the directors. But the reserve management power contained in that article means that that's not quite the whole story.
Sorry, it means it's...
Not quite the whole story. Special resolution requiring 75%, and by this point we have in the region of 90%.
But was there any direction given by special resolution?
No, there wasn't.
So why does that help? The business of the company was to be managed by the directors.
Well, the judge's point is effectively, or as Mr. Hollington puts it, that the shareholders effectively ran the business without reference to the board. And I accept, I have to, that there were no formally passed special resolutions during that period. There were no board meetings because the chairman, Mr. Faulkner, never convened any. So I have to accept that there are no special resolutions, and to that extent, if that is correct, there has been an irregularity, but it goes to the question of whether or not it is prejudicial.
I mean, just talking more generally for a moment, Mr. Faulkner was a director.
Yes.
The business of the company is to be managed by the directors. Normally, you expect directors to have access to information as to what's going on in the business. Here you have a director shareholder being denied information. Is that all right?
Well, my lord, the fact finding that the judge made, that's why I've taken you in some care through the allegations of failure to provide information. Of the failures to provide information which the judge considered, of the 6, the one aspect in which he makes a finding that there was a clear withholding was in relation to the discussions with Carr. Now, before him, we advanced a submission which, excuse me, I haven't developed in the skeleton argument. I think in fact it is developed in the skeleton argument, but the short point is this, that down to a fairly late juncture, the negotiations with Carr were negotiations for a merger under which the shareholders in CPGL would have swapped their shares in that company for shares in a merged entity. And there are provisions in the articles, there are drag provisions, which effectively meant that the minority shareholders would have been entitled to be served with notice, and they had particular entitlements to information in that regard. But we disputed before the judge that they were entitled to know anything more about how we propose to dispose of our shares. There is a point that comes at which that merger proposal founders, and it instead becomes a transaction of sale. And at that point, it's a different animal. By that point, the resolution to remove Mr. Faulkner was already pending for the general meeting. So I accept your lordship's point in relation to information, but that was the extent of the judge's finding in relation to failure to give information. And as I say, I accept there are no special resolutions. But if the question is not was there unfairness, was there a shortcoming in corporate governance, but was that shortcoming prejudicial, then I respectfully submit, had there been, there is only one conceivable outcome that could have been driven by special resolution. Just to develop that a little bit, one of the points which the judge makes is, well, there are particular protections within the context of the shareholders' agreement in relation to the balance of power as between the board and the shareholders. One point that's made, for example, is that there's a provision in the shareholders' agreement that the board sets policy and the company will be managed by the policy. That predicates the occurrence of board meetings. And that feeds into the second point that I'm just about to make, which is that there were none because Mr. Faulkner never called any.
And I shouldn't delay you a moment, but would it have been all right for you to pass a special resolution saying that in future the management of the business was to be entrusted to the shareholders, your shareholders, to the investors, rather than...
No. I mean, that's
so the fact that you could have passed a resolution doesn't seem to help very much.
No, forgive me, I'm not making the point in quite that broad brush way. I think the point that's being suggested is that fundamental decisions are taken about the direction of business. Just to take one example, service of what's called the last time buy order on Selex, the one client that Newton Aycliffe had that generated cash. And the point the judge makes is, well, there's no board decision. He's absolutely right about that. He finds, as a fact, Mr. Faulkner knew all about that. And Mr. Faulkner chose to call no board meeting. So if the question is, absent a board meeting, could the shareholders have passed a special resolution under the reserve management power saying, call the last time buy? The answer is yes, they could. They didn't. But then the question becomes whether or not that omission on a corporate governance level is prejudicial.
I mean, what business did anyone have serving that notice? Who had entrusted to those who served the notice the power to serve that?
The notice was served by from recollection, by the chief executive, the interim chief executive, who was Brian Bulgar. And it was either him alone or it was him in conjunction with Mr. Jackson, who was the employee of, I think, CPUK, who actually ran the Newton Aycliffe plant. And as I've indicated, on the judge's findings, Mr. Faulkner knew all about it. My lord, the second provision in the standard table A that I wanted to show you, again, it's fairly familiar stuff. Bundle page 2415, Regulation 88. Bottom of the page, subject to the provisions of the articles, the directors may regulate their proceedings as they think fit. The director may, and the secretary at the request of the director shall call a meeting of directors. So cite that as the basis for the very obvious proposition that at any point before he was voted off the board in October 2016, Mr. Faulkner could have called for formal board meetings and insisted that all decisions affecting the company's future be put to formal vote. I make the point that he is the chairman of the board of CPGL. I don't expect anyone to call a board meeting, it's the chairman. Had he done that, he would, of course, have had the special protections to which the judge refers to in his judgment in relation to both quorum and qualified majority voting. He had effectively a veto on resolutions under clause 7.13 that he could have exercised at any time if he had insisted on strict governance by board resolution. Mr. Faulkner never did that, despite various opportunities. And so far as that is concerned, it's worth highlighting a few aspects of the findings the judge made. Go back into the judgment. The first relevant paragraph is paragraph 53. And if you have that, bundle page 101, see, this is when the judge is still in the foothills of the factual account, and at the top he's dealing in this section with the period from 2010 to 2013. And he says at 53, another feature of the business throughout this period, and indeed generally, is that it was managed in an informal way. That is to say, no record of any board meetings taking place at any point in the 6 years between the time of Vollin's original investment and departure of Dr. Sachs in 2016. 3 lines up from the bottom, the day-to-day management of the company was left to Dr. Sachs. Those working for him supported, it seems, in managing the ongoing relationship with the investor Vollin. So the established pattern for a period of 6 years, down to March, is management by the chief executive in consultation with the funders, who are at all material times the only thing that stands between this company and bankruptcy. Then if you turn on in the judgment...
Just remind me, how did Mr. Bulgar become chief executive? Who appointed him to that?
He was appointed to that position effectively by the investors at an investor-only meeting in April following Dr. Sachs's departure.
Does that count as an appointment as chief executive?
Well, it could have been affected by means of special resolution, and it could have been ratified at any point afterwards if somebody had taken a formal point about the absence of one. The next passage I was going to show you in the judgment is on bundle page 119. So the evidence shows, so that's the position before Dr. Sachs goes. There are then two separate findings made by the judge of occasions when we in fact asked Mr. Faulkner to call board meetings and he didn't do it. The first is the one you see at paragraph 149. The date here is Sunday the 13th of March. So this is the day before the meeting at which Dr. Sachs is asked to go. And what's happening here is that Mr. Berkey, who's one of the officers of Q, is emailing Mr. Faulkner. And you can see the email is set out at length, continuing over the page. And at 1:20, just reading it beneath the second hole punch, the majority investors have lost confidence in Sachs, won't provide further funding for the company. Since personally we're also directors of the company, the above obviously goes to whether the company can remain as a going concern. We therefore urge you to call an immediate board meeting with the agenda item of discussing Jonathan's position. So we in fact expressly asked Mr. Faulkner, the chairman, to convene a board meeting, and he did not. Because as the judge found, he gave his informal agreement to us doing what we then proceeded to do. That's the first of two references to that in the judgment. There's then a second one dating from rather later in the chronology that you find at bundle page 133. Paragraph 229 on that page. We've moved on quite a way. We're in August. At this point, Mr. Faulkner is professing concerns about governance. And out of the blue, he asks for a meeting with Andre de Court, who is the representative of Mr. Abramovich's vehicle, Linda. And then there's a discussion between them. And just looking at 229, a call with Mr. de Court was arranged for the 9th of August. Mr. Court wasn't able to join. Instead, Bolger and Fletcher spoke to Faulkner. Although he didn't disclose it at the outset of the call, Mr. Faulkner was also accompanied by a lawyer, Rebecca Ferguson from Gordon Dadds. So just pausing there, Mr. Faulkner throughout the material time was advised, legally advised by Gordon Dadds here. There's actually a reference earlier in the judgment to the fact that Brian Cave were acting for him from May onwards in relation to a possible claim. And you can see that the judge there sets out a quotation from an email which Mr. Fletcher sends to Mr. de Court, summarising the outcome of the call. And in the third and fourth lines, you can see he says, we've agreed to hold board meetings if he gets off his arse and calls them. And I did just want to develop that by just showing you one contemporaneous document in the supplemental bundle. It's in volume 1, tab 45. Page 232. When you get there, you'll find an email from Mr. Fletcher to Mr. Faulkner, copied to Mr. de Court and Berkey. And the email in the judgment is an email from the 9th of August. This is from the following day. So this is the email that Mr. Fletcher sends Mr. Faulkner the next day. Dear Mark, I'm writing following the phone call yesterday. On that call, we agreed 3 action points. 1, would circulate your fellow board members your comments, questions and open issues on the accounts. And then 3, for so long as you remain chairman, you would seek to call regular board meetings in order to ensure that you are properly informed about Compound Photonics, its direction and future strategy, and in the interests of good corporate governance. So the position arrived at by August is that Mr. Faulkner has agreed to call board meetings to alleviate his professed concerns about governance. Despite that, he never does. Now, we say that inactivity on his part is important in 2 ways. First of all, it goes to the question of whether there was any breach of agreement by managing the company without formal board meetings. And secondly, even if there was, it again goes to the question of whether that breach was prejudicial. If you put away that supplemental bundle, so far as that first point breach of agreement is concerned,
Was there a response to that email? It asks for one, isn't it?
I'm not sure that there is, my lady.
Confirm the above action points, etc.
I'm not sure that there's an answer to that. I'll be corrected if I'm wrong. I don't think there was an answer. There certainly isn't an answer suggesting that wasn't the position arrived at. So, was there a breach of agreement by having no board meetings, and was it prejudicial even if there was? So far as that first point is concerned, we've made the point in our skeleton. The judge treats this question as referable to the general duty of good faith in clause 4.2, but that overlooks the fact that the shareholders agreement contains a rather more specific provision dealing with board meetings and their frequency. And back in the shareholders agreement in the core bundle at tab 20, I'm asking you to go to page 546. We're back in the section of the agreement which we've looked at already, section 7, headed the board. And the provision to focus on now is over the page, and it's clause 7.10. Unless otherwise agreed, the board shall meet in the United Kingdom once every 4 months, and otherwise the circumstances require. So the short point is that it was always open to the parties to, quote, otherwise agree, unquote.
Sorry, 6 point?
I'm so sorry, clause 7.10 on bundle page 547. And I'm focusing on those opening words,
Yes.
unless otherwise agreed, the board shall meet. So it was always open to the parties to otherwise agree and dispense with meetings 3 times a year. And we respectfully suggest that on the facts, it is absolutely clear on the judge's own findings that they had done precisely that long before 2016. It remained open, of course, to any director to decide that circumstances required an ad hoc meeting within the meaning of that provision. And as I've shown you, Mr. Faulkner never did, despite being the chairman and despite being encouraged by us to do so in pretty emphatic terms. Now, in our skeleton argument, we relied on 2 authorities in amplification of that point, and I'll show you them very briefly. The first is in volume 6 of the authorities bundle.
You've got a quarter of an hour, so I've just checked that that is best used by looking at the authorities.
All right, I'll take the authorities as read. Your lordship has the references in our skeleton argument.
Just remind me which authorities you're relying on here.
We're relying on the decision of Carroyne,
Yes.
paragraph 108, authorities bundle 6, tab 38, page 1858.
Yes.
And that is an authority for the proposition, which a number of other cases establish as well, that it is not on to complain about a failure to convene board meetings if you are a director, if articles are in the standard table A form, with the consequence that you could have called one yourself at any time.
Yep.
And then I've also cited Lord Sales's decision in Fisher and Cadman, volume 3 of the authorities bundle, tab 17. And I've referred to that to make the point which Lord Sales does, that a course of conduct may mean that it is not inequitable to manage a company in a relatively informal way, but that, of course, on reasonable notice, any party in interest can insist upon more exacting standards, can insist that the parties go back to the letter of the articles.
Yep.
Within that, it's specifically paragraphs 90 to 93 of Mr. Justice Sales's comments. Now, I need to show you then what the judge says about that submission, which I did advance to him. So back in the judgment, bundle page 180, it's paragraphs 454 through to 455. And if you just cast your eye over that, in a nutshell, what the judge said was that Mr. Faulkner reasonably believed the investors' representatives didn't think very much of him. And then the important sentence, the end of 455, the die was cast, no doubt to Faulkner, the idea he should seek to invoke a governance structure which his majority considers to have manifestly failed, and I underline these words, and had already in practice overridden, seemed unrealistic. So I have two things to say about that. The first is that the judge appears to be discussing the point here in relation to whether Mr. Faulkner should have called board meetings at the level of whether or not it was reasonable for him not to have done so.
Which is not the question, you said.
Precisely so. Point is, whatever his reasons, he had in his own hands the means to remedy his professed grievance. The second point is that the words I've just asked you to underline at the bottom of paragraph 455, that reference to the investors having, open quote, in practice overridden, close quote, the governing structures, proceeds on the assumption that Dr. Sachs's exclusion had been wrongful. And if you turn on to page 189 in the bundle, there's another passage which makes the linkage in the judge's mind, we suggest, clearer still. You've already looked at paragraph 504, where the judge reaches the conclusion that Mr. Faulkner's removal is prima facie wrongful. And then starting at paragraph 505, he goes on to address the separate question of, is it justified by the way in which Mr. Faulkner behaved during this period? And in the context of that, he says what you see at paragraph 509. The examples I've called Faulkner's strange behaviour must be put in context. It's relevant in assessing them to identify what one might describe as their root cause. Here it seems to me that the position is plain. The oddities in Faulkner's behaviour can all be traced back to the decision made by the investors to exclude Dr. Sachs, and thereafter to adopt a structure for managing CPGL which left no room for involvement. I make the obvious point that that decision was ratified by a board resolution Mr. Faulkner signed, and he agreed it for the relevant meeting on the Monday. But leaving that point to one side, what I suggest is clear from that is that the judge views the whole of this topic through the lens of the conclusion that he's already arrived at, that there has been a fundamental subversion of the Constitution by the removal of Dr. Sachs. And if you're with me on the submissions I've made in relation to the correctness of that, we suggest that that imports the consequence that his answer to the point that I made to him on the basis of Carr falls away. Well, that deals with finding 5, and that only leaves finding 6, which was the judge's findings that the directors breached their duties in a 7-month period because CPGL was managed without formal board meetings. For that point, you can turn very quickly to page 184 in the bundle, and it's paragraph 477. Full extent of the discussion is those 6 lines that you see there, and simple point to make, once again, this founds on the conclusions that the judge has reached about the constitutional settlement. Last sentence, the old constitution was in a very real sense a dead letter and for all practical purposes was ignored. So that is all I was proposing to say on our appeal. Given time, I'm going to take the 2 remaining topics very briefly, and I may just get through it in 10 minutes.
I think you've got 8.
I may get through it if not. So the first point is this. You've seen from your pre-reading that one of the submissions that my learned friend develops in his skeleton argument is an extensive passage in paragraph 11, is that when you read the judgment as a whole, and in particular in the light of what he says on the permission to appeal application in July, the judge did reach a finding of deliberate bad faith. And just to assist you in appraising that, I'm going to read very quickly some dates into the record. Last day of trial, 4 December 2020. Judgment circulated in draft 25 March 2021. Formal hand down 31 March. consequentials hearing fixed for the 27th of July. On the 22nd of July, we circulated to the judge and to Mr. Hollington a copy of the skeleton argument in support of this appeal in substantially the same form that it was eventually submitted to this court. But on the 27th of July, the judge declined our permission application, giving very brief oral reasons. Then 3 days later, on the 30th of July, we received the judge's form N460, setting out written reasons. And those are important because in those written reasons given on the 30th of July, he refers to, quote, conscious and deliberate, quote, unquote, breaches of the agreement. And an important point, technical point, but important, the order from the consequentials hearing was perfected by being sealed on the 24th of August. Now, in the authorities bundle, you have a decision, and I don't have time to take you to it. For your note, it's in the supplemental authorities bundle, tab 70, called Greenwich Millennium. And that is, as far as we can identify, the only case in which there has been a reasoned decision by this court on the question of whether or not views expressed by the judge after delivery and handing down of the main judgment are germane in analysing the judge's reasoning. And if you look at that particular paragraph 11, you will find a decision by Lord Justice Jackson, where he says in principle it can come in. And the reason that he gives is that if you look at what the Court of Appeal says in Emery and Reinbold, it's always open to a judge to supplement their reason before the order is perfected. But the short point in relation to that authority is that it is different from the facts of this case. And the reason for that, when you come to look at that decision, is that in that case, one of the points which was taken before, what happened there was the same as here. The would-be appellant submitted a draft skeleton to the judge and asked for permission. One of the points taken in the skeleton was specifically about a failure to give reasons. And when you look at Lord Justice Jackson's judgment, he refers to a supplemental decision which the trial judge, Mr. Justice Coulson, gave. That's not available on the ordinary online sources. But by looking at what Lord Justice Jackson says, it seems to have been a reasonably significant written addendum. And that is fundamentally different from what happened in this case. It is one thing to say if a judge is invited at hand down before the order is perfected to give additional reasons, or to make additional findings, and the judge hears adversarial argument on that point. It is one thing to say that the decision that the judge then takes is admissible. It plainly is. But if all that happens is that the trial judge is asked for permission and declines to give it by reference to an extemporaneous summary of what he said, in this case, 4 months previously, with the greatest of respect, the judge's extemporaneous summary is neither here nor there. The question is simply, what does the judgment say? Those comments are no more relevant than it would be to say, well, during the course of closing oral submissions, the judge said the following.
An analogy with the failure to give reasons case would be, for example, when declining permission, if a point is arguable, the judge could say, well, actually, it played no or any minimal part in my reasoning. That falls potentially into the failure to give reasons type situation.
Yes.
But insofar as there are fresh findings, as it were, you would say that's a different category.
Right. And what you'll see when you look at the judge's oral and written reasons is that there is a reference for the first time to a concept of repudiation. There is no suggestion, there was never any pleaded case of repudiation, there was never any suggestion this contract had come to an end. The excellent reason that petitioners continue to insist upon its performance down to and including at the consequentials hearing.
I'm not sure the judge means repudiation in that technical sense.
No.
He means deliberate ignoring of the Constitution as he sees it, which takes us back into all the other issues which are dealt with in much more detail in the judgment.
Yes. I think actually what he may have meant was renunciation rather than repudiation. We may have to come back to the evidential basis for that. But the short point is there was no argument or discussion about that. And so effectively what you're left with is a summary which we say with respect is neither here nor there. The only other point I was going to open in the remaining few moments open to me, the court is aware that I have a strikeout application afoot in relation to the remaining portion of my learned friend's grounds of appeal. And that is the aspect which seeks to invite this court to determine de novo the question of whether or not adverse inferences should be drawn against Roman Abramovich, Dr. Abramov and Dr. Frolov, inferences of bad faith from their failure to give evidence at trial. I took the court yesterday to the Skykick decision, which my lord is very familiar with, to the point that inferences of that kind are effectively an invitation to this court to find something akin to fraud against those three individuals. Set out our stall fairly clearly in our skeleton argument. This point was taken below. The judge didn't make any finding about it. As I've indicated before the permission to appeal application, we flagged absolutely clearly where we were going with this point about bad faith and knowledge. There was no suggestion made to Mr. Justice Johnson in July that he ought to go further and deal with this, despite the fact that, as I showed you in submissions yesterday, paragraph 1 of the petitioner's written closing submissions described this as the fundamental point. The petitioners weren't there, specifically by reference to the question of mental state. We submit, and I'm going to show you one short passage in the white book in a moment, that there was an obligation on the petitioners to ask the judge to make that determination, and that they cannot rely upon their failure to do so now to invite this court effectively to undertake an exercise which on well-known principles it is, with respect, ill-equipped to deal with. And the short way to deal with this point, I floated the suggestion in our skeleton argument that this comes very close to a Henderson and Henderson type abuse. They've run a point, they could have had it determined, they didn't do so for whatever reason, so they now want this court to deal with it. But the short point is the provision of the CPR, you'll note Rule 52.21, which provides that all appeals are by way of rehearing unless the court makes a contradiction. We respectfully suggest that in the circumstances I have described, Your Lordship looks as if you want to have a look at that.
It may just be that I misheard you. Could you just repeat the submission?
Yes. Well, perhaps we ought to look at it just in case I have, unless I have summarised it incorrectly. So in the current edition of the White Book, it's 1917. Every appeal will be limited to a review of the decision of the lower court unless B, the court considers that in the circumstances of an individual appeal, it would be in the interest of justice to hold a rehearing. So the default is review for error only. And a point we've made in our skeleton argument by reference to a decision to which my Lord Justice Snowden was party to fairly recently, it's questionable whether this is even within the rubric of a rehearing. The simple point is it hasn't been determined at all. But we say that in those circumstances, this is plainly not an appropriate question to allow Mr. Hollington effectively to open to this court as a trial court. I mentioned the question of whether or not counsel should draw the court's attention to omissions in reasoning.
Now, you've definitely had your time. Can you just give us the references rather than...
It's paragraph 40.2.1.3 in the current edition of the White Book, page 1382, going over the page 1383. We gave one case as authority in our skeleton. There's a much fuller citation of the authorities there. I do apologise for overstepping.
Thank you very much. Mr. Holt.
Would your lordships am I able to give me 5 minutes to organise my papers?
We'll go up for 5 minutes.
Thank you very much.
All right.
Sorry.
It is.
Oh, thank you. Sorry, no.
Oh, yeah.
Yes, yes, I agree. Yes, very right. To make a very obvious point. This was so helpful. Thank you so much. is, I used to do a bit. Yeah, some kind of silk things. So I've got a case and because I've got very busy, they said we need to get another silk sort of one study. That would work. Here's the list of silks that we use. And the names of it were, really, really big stuff. For most of them, I picked out some really good big stuff. Saying, luckily, we've managed it. Richard, what would you tell all of it? This was about because he knows it all so well. Things like that job. Nothing.
May it please, my lords, my lady. I'm going to open my submissions in a theatrical way, in this way. This case poses no novel issues of law. The issues for decision are almost entirely factual, to which well-settled principles, which are very familiar to this course, will then fall to be applied. To a very large extent, the meaning of a contractual good faith clause is a factual question. I gratefully adopt the closing written submissions of my learned friend at trial. I do so not only for theatrical purposes, but also to make the point that the case now advanced on this appeal is in fundamental respects, not in all respects, but in fundamental respects, radically different from the case advanced at trial.
Just let me ask you about that. So, supplemental bundle 3, tab 78, we find the closing submissions.
Yes.
So take, for example, paragraph 315. Do you adopt that? Tab
78.
78.
Page,
Page 914.
Page 914. No, because what happened was...
So I'm only raising it now in the sense
Yes.
I thought you were saying you adopted what?
Oh no, well only those words, only the opening words.
Only the words you read out.
Only the words I read out.
Yeah, I
Yes,
see. Okay.
Yes. Yeah.
Yep.
Yeah.
Yes.
Because although on the face of that, paragraph in the in his written closing submissions, it appeared as if he was arguing for a duty of honesty. In oral submissions, it appeared as if he was backtracking and accepting that the duty of good faith did involve the ingredient of fidelity to the bargain, which was the expression used in Macquarie and in Yan Seng. So it looked as if, although he had, well, not to personalise it, the investors were resiling from their position in their opening submissions by now advancing and closing that the duty of good faith only entailed a duty of honesty. In oral submissions, he reverted to the position, which was his opening position, which was that the duty of good faith did entail a duty of fidelity to the bargain. Now, obviously, there was a difference between us over what that bargain was. In other words, what the agreed purpose of the agreements were, or in other words, what the spirit of the agreements were, or to put it another way, what the legitimate expectations of the parties.
Wait. Sorry, I'm going to stop you rolling about three different principles in there. Can you be clear what you contend the content is and why you're complaining about what Mr. Gledhill is doing in terms of that there are a number of different contexts. One is a number of different concepts which have been floating around. One is fidelity to a bargain,
Yes.
whatever fidelity means, whatever the bargain means.
Yes.
There's another one about a spirit of the bargain, which is not necessarily encapsulated or the same as the first point. And then you suddenly introduce legitimate expectations, which come from a very different area of law. And I didn't understand anybody's been talking about legitimate expectations at any stage of this game.
You haven't yet been taken to the authorities, but if you go to Macquarie, or you go to Yan Seng, where they refer to fidelity to the bargain, they put it in different ways. Some of the judges put it by reference to frustrating the purposes or the objectives of the contract. Some refer to it as giving effect to the legitimate expectation of parties. I was doing no more than that. And I will take you to the authorities. Right. And I accept that the authorities, rather frustratingly, use different terminology to refer to what is essentially the same thing, but I will be coming on to that.
But going back to this, I mean, ignoring what was said in paragraph 315, on this appeal, Mr. Gledhill accepts argues for an autonomous dishonesty duty, but then in relation to what he describes as the derivative duty of fidelity to the bargain, he accepts again, consistent with what you say he did below, that dishonesty is not an ingredient of that obligation, or honesty is not an ingredient of that obligation. And that we can see that, for example, from page 169 of yesterday's transcript.
Indeed, my lady, in his oral submissions, and then that is different, and this is the other point I was making, that's completely different to what his case was in his skeleton argument. His skeleton argument was that it was a duty of no more than a duty of subjective honesty.
Skeleton argument here or below?
Here.
Right.
And we answered that and said, no, you're obviously wrong on that, and even look at what you argued in the court below. So we said that that's wrong. And then on the basis of that, he said that the judge, in arriving at what he conceived to be or concluded was the constitutional settlement, had implied a term. That was his argument. His one argument on the way in which the judge had approached the constitutional balance. And we responded to that and said, well, that's obviously misconceived, because the judge wasn't implying a term. He was giving his conclusions as to what the agreed common purpose of the agreements were, the articles of the Shareholders Agreement. Now, in this court, there's a radically different argument advanced, which, in our respectful submission, remains fuzzy at the edges. First of all, there's an argument that it is a duty of honesty, but an autonomous duty of honesty, which I think this is the first time that that argument has ever been advanced in a common law court in those terms. And then he says that you can't conclude that the agreement has anything by way of an agreed general purpose. Otherwise, than by implying a derivative implied term, which again, in my respectful submission, is a completely novel argument, which is inconsistent with all the authorities. So I will be taking a look, this court through the authorities in some detail. But in my respectful submission, there is a large amount of consensus as to what the duty of good faith entails, which was the position in my respectful submission in the court below. There was a consensus between us as to what the duty of good faith entailed. And it included, for example, a duty of fidelity to the bargain. Although I accept the Malone friend never accepted that it went beyond a duty of fidelity to the bargain. But the appellant's case on this appeal is, as I say, in my suspicion, completely inconsistent with the authorities, and it won't, in my respectful submission, it would be extraordinary if this court did not follow a long line of cases, which is that a duty of good faith is heavily dependent and sensitive to the context, but the context here is really unique. Not only is it a long-term relational contract of the type that Mr. Justice Leggett, as he then was, referred to in Yan Sang. In my respectful submission, Mr. Justice Leggett was consciously or subconsciously picking up on a line of authorities in Australia.
Why do you say it's a long-term relational contract? We haven't looked at what that actually means. I mean, how long was the Shareholders Agreement expected to last?
Well, it had forever, potentially. But there were exit provisions where they intended to have an exit by way of a management buyout in 2 years or 4 years.
Right.
But potentially it was forever.
A long-term relational contract. Certainly, some of the examples we've seen are considerably longer than contracts which aim at a 2-year exit for investors or 4-year exit for investors. They're effectively, literally long-term supply contracts. I mean, if you're going to say that this was clearly a long-term relational contract and that has some particular consequence, I, for one, would like to see what people actually understand by that concept.
I would put...
It's a relational contract,
yes.
It deals with a relationship. But companies are inevitably relationships. But if the proposition is that every shareholders agreement, which doesn't have a short-term end date, is a long-term relational contract such that it automatically start implying duties of good faith, never mind if it's actually written in, then that's a really far-reaching submission that I need a lot of help with.
And I don't make that submission because I don't need to, because there is an express duty of good faith here. But in perhaps the better way in which I could have put it is that if you look at Jan's saying, the reason why Mr. Justice Leggett thought that there were good grounds for implying a duty of good faith, where there wasn't an express duty of good faith, was because the relationship was likely to last a long time, but more particularly would last a long time so that circumstances would arise and events would change and issues would arise which the parties could not reasonably be expected to have governed at the beginning of their relationship. And this is such a relationship. That's why, in our respectful submission, there is a duty of good faith, an express duty of good faith, because the parties realised that they couldn't provide for everything that might arise in the future. They couldn't provide for things that couldn't be set out in black letters, couldn't be set out in absolute terms like "thou shalt not remove Sachs or Faulkner." It was more subtle than that. There were understandings, and I would say expectations, because some of the cases talk about that. But in the event, the nature of this contract was such that it was likely to give rise to issues arising which could not be expressly provided for in advance, so that the parties agreed an express duty of good faith.
Although Yam's saying, we looked at Yam's saying, the contract in Yam's saying was very different from the complex lawyered documents that we're dealing with here.
Which are even stronger, and I will take your lordships to those. What I was going to do, and obviously,
although I'm going to keep picking you up, I'm afraid, because I do want some precision in this.
Yes.
If you keep talking about expectations and legitimate expectations or otherwise, don't you run into the twofold problem? One is that this is clearly not intended to be a partnership or whether a fiduciary relationships. And secondly, I think, wasn't it Lord Hoffman who said at one point he wished he'd never even mentioned the concept of legitimate expectations because of all the problems it's caused?
That was in the context of how one applied the test of unfairness in the context of the unfair prejudice remedy. In my respectful submission, it is still, on the authorities, an expression that is useful in deciding what the fidelity to the bargain means. But I'm perfectly happy to avoid using those words, legitimate expectations, and to focus on the words which the judge used, which was the agreed common purpose.
Well, why don't we focus on clause 4.2 for a kick-off? Because that's the actual clause that do you accept the judge asked himself the right question in paragraphs 346 and 347 of the judgment?
Your Lordship has those in mind more clearly than I do. And President, excuse me, it's really based on this saying that no equitable constraint is relied on. I accept that, and I can take your Lordship to where I actually said that.
No,
Yeah.
I asked Mr. Lethill the same question, actually, whether he was happy that the judge had asked himself the right question. So I'm only doing the same.
Yeah, and I said I couldn't. I said I couldn't. I was not basing myself on any equitable considerations. I was basing myself on clause 4.2.
Right. And
I knew it led to breach of contract.
Breach of contract. So it's breach of the express duty of good faith, which is breach of contract, which is potentially unfair prejudice following O'Neill and Phillips and subsequent authorities.
And so is the judge right? He says, when he says the central question, or at least in this part of it, the central question is whether clause 4.2 can be interpreted or read in a way which prohibits the removal of Dr. Sachs and Mr. Faulkner from office.
Well, no, in my respectful submission, that's not what the judge found. It wasn't the way that we put the case below. We didn't say there was an absolute prohibition against removal. And as the judge subsequently...
Subject to...
Misconduct.
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 No, I understand that.
Yeah. But that was one aspect of the agreed general purpose.
Right, but barring Dr. Sachs or Mr. Faulkner, as it were, having been found with their hands in the till.
Yes. Well, yeah. But anything justifying...
Yeah, okay.
Yeah.
But
that wasn't just...
Barring that,
Yes.
do you say that they were irremovable?
I do, but that isn't the only way. That is not the only way in which we put the agreed common purpose. We put the agreed common purpose, and the judge found this, that the another aspect of the agreed common purpose was that the investors should not obtain total board control. That's the way I put it in as recited by the judge at paragraph 336, at the bottom of the page. There were two particular agreed common purposes, namely entrenchment of the positions in management of Dr. Sachs and Mr. Faulkner. And then I think I may have at times used the word corollary, but perhaps it wasn't quite a corollary, because it was another aspect of the agreed common purpose, distinct from the first, that it was the prevention of the investors from obtaining control of the board. And there was another aspect which the judge found, which was, and this really is the fundamental, the fundamental purpose, that the minorities were entitled to be represented on the board.
Well, nobody doubts they're entitled to be represented in the sense that the agreement set out that they would have representatives at the start.
At the start. But they would continue to have representatives on the board. So that if Sachs or Faulkner ceased to be directors at any time, they might have died for natural causes, they might have been removed for misconduct, or circumstances might have changed where they agreed that there were other people who were better able to be on the board as, amongst other things, representatives of the minorities, that they would have such representation. And what went wrong... Can
you show us the paragraphs, can you show us the clauses of the articles of the Shareholders Agreement that you can say support that?
It is 516 to 520 of the judgment.
Yes,
yeah.
Yes. Where the judge went out of his way, and that's a very good example of where he said, it wasn't just the removal or of Sachs or the removal of Faulkner, it was the failure to consult with the minorities over whether there should be any representation. And that, in my respectful submission, was ultimately the last interest and the most important interest that the minorities had, which was that if for any reason Sachs and Faulkner went, and let's assume that the agreement didn't go so far as entrenching them in their position, that nevertheless the minorities would at the very least be consulted and offered replacements for them on the board.
Now, don't let me deflect you from answering my Lord's question.
Yes.
There's reference in these paragraphs to 24, 17.7, 7.8,
and
14.2.
Yes. Shall I? I'll go to the. I'm happy to go straight to the.
I am concerned, Mr. Hollington, that you shouldn't find your time has run out without developing your submissions in the way which you had in mind.
Yes.
So, I mean, it may be best if you revert to the structure that you intended, and then we see where we get to.
Well, with my Lord Justice Snowden's leave, I was going to. What I was going to do was, with that theatrical introduction, was then to say basically what my submissions are going to be, and then to develop them.
There's always the risk of theatrical introductions.
Yes,
You find
yes,
that
yes.
you're drawn into all sorts of points that
Yes,
might be better developed later on.
I take my Lord's point. So, what is essentially our case, and the way in which I will develop my submissions is that first of all I will deal with the point that this wasn't a case advanced at trial. What is the consequences of that? Then I will make the general point that many of the aspects of the judge's judgment are in our submission either factual findings or evaluative findings, which this court should be slow to interfere with. And so far as evaluative findings are concerned, I have in mind two particular aspects of the judge's conclusion. First of all, the process by which Mr. Sachs was removed. That, in my estimate, was an evaluative decision which should not be overturned unless it is plainly wrong or it can be demonstrated that the judge made an error of principle.
What do you mean, evaluative findings on process?
I mean that when the judge held, and Malone Friend went through the passages towards the end of his submissions, when he held that the process by which Dr. Sachs was removed was an unfair process, that was an evaluative decision in the sense that it turned on the judge's assessment of the facts, and this court should not interfere unless he was plainly
Speaking
wrong.
for myself off the cuff, I'm not sure that's right. It's an analysis. It's a conclusion by reference to the legal.
Oh, my lady, I quite accept that if he was wrong on there being any duty of fair dealing, then that would be an error of law upon which you could interfere and set it aside. But if he was right that there was a duty of fair dealing, then in his assessment of whether Dr. Sachs was dealt with fairly, that in my respectful submission, was an evaluative decision that this court should be slow in interfering. I also...
And just to be clear, when you say fair,
yes.
you are saying, I think, fair dealing as part of the meaning of good faith under clause 4.2, rather than running straight to fair prejudice.
Yeah, no, I'm only relying on a breach of contract. And the breach of contract is primarily clause 4.2, but it also extends to clause 5.2, and I'll deal with Malone Friend's argument about whether proper corporate governance refers only to the management of the projector business, or whether it extends to the functionings of the board. And in my respectful submission, that is a bad point that Malone Friend takes, that the fact that the business...
I think you're getting drawn into the detail when it might be better to
come back. Yeah.
Wait.
So I'll make those two preliminary points, which really go to the role of the appellate.
Sorry, at the risk of slowing you up again, I think you said many aspects of factual or evaluative, and then you said there were two particular points. One was process. Was there a second point?
Whether there were good reasons for the removal of Mr. Faulkner.
Yeah.
And that, just to anticipate what I said, that was one of the fuzzinesses in the case as put by Mr. Glenhill in opening. When it was put to him by Lord Justice Snowden, well, are you saying that they could be removed at will without any good reason, irrationally, capriciously. It wasn't clear what Mr. Gledhill's answer was. And in my respectful submission, if this court disagrees with the decision of the conclusion of the judge as to what the agreed common purpose was, and concludes, for example, that the entrenchment of Sachs was only so long as there were not good commercial reasons for his removal, then that would be an answer to the removal of Dr. Sachs, but it wouldn't be, in our respectful submission, an answer to the removal of Mr. Faulkner. We submit that Mr. Faulkner, if that was the true analysis of the agreed common purpose here, Mr. Faulkner was removed when he had the insolence of consulting with the minorities. And it was all part and parcel of the investors' determination to sweep aside the Constitution, which leads me on to perhaps one of the most important points, then so far as substance is concerned. I will begin with the provisions of the Constitution, which slightly takes me out of the order of the roadmap that your lordships and my lady have. And I will be submitting that these are highly unusual, unique provisions, in particular the provisions relating to the quorum and voting at board meetings, which can only have had the purpose of ensuring that the investors did not get control. Why else would you give to these two individuals, Sachs and Faulkner, those extraordinary veto powers and voting powers, unless the agreed common purpose was to stop the investors getting control? I will then deal with number one of our roadmap, which is to take you through parts of the judgment that my learned friend was obviously careful not to take you to, which established that, and the judge found that the investors saw the problem about the restrictions in the Constitution early on in 2016, and because they regarded those provisions, regardless of their finer meaning, as obsolete or a dead letter, with effect from the meetings on the 12th, on the weekend of the 12th to the 13th of March 2016, they set about ignoring the Constitution, took over the management of the company, removed Dr. Sachs, excluded Faulkner from information and management, in some instances positively and dishonestly deceiving him as to what was going on, and then in exasperation at his insolence in consulting with the minorities, removed him in October, and thereafter treated the company entirely as their own. And the relevant passages in the judgment that I will be taking you to are those identified in number one of my roadmap, although there will be one or two additions that I will be taking you to. Fortunately, your lordships have read the judgment, so I hope that I certainly won't be reading them out to you. I will merely be drawing your lordships' attention and my lady's attention to them. And if necessary, I can take your lordships to the argument below, which made it quite clear that whilst we did rely upon the removal of Dr. Sachs as in itself wrongful on all grounds, one of our main focuses at trial was also on the whole continuum of events which I've just summarised, which is what the judge found, and which resulted in the investors taking complete control of the company, which, in my respectful submission, was against the agreed common purpose of the Constitution. And I would point out that the removal of Dr. Sachs was obviously a seismic event, but it did not immediately lead to solicitors' correspondence or involvement. It was the way in which Mr. Faulkner was treated and ultimately removed, which led to the involvement of solicitors and eventually these proceedings.
I mean, on your interpretation of clause 4.2, the removal of Dr. Sachs was itself unfairly prejudicial, wasn't it?
It was.
And could have been prohibited?
Yes, just as it could have been prohibited if it had been a quasi-partnership. If it had been a quasi-partnership, there were legitimate explanations that Dr. Sachs could have applied for an injunction. He would never have got one, of course.
Why not?
Because I'll take you to the authorities. First is the Bentley Stevens case, which I'm sure my lord is well familiar with, where I think Mr. Justice Plowman said...
Yes, but he refused that on the basis that it could be done legitimately. There was no point in granting the injunction because as I recall that case, it was open to the majority to remove him legitimately. And what he's complaining about is that it was. But on your interpretation of 4.2, this was a clear breach of clause 4.2, and could have been restrained. I mean, the only reason I'm asking is I'm not suggesting something turns on, as Mr. Gledhill accepted. Nothing turns on the question of whether Dr. Sachs should have sought an injunction. That's not the issue I'm getting at. What I'm trying to get at is the question of whether the judge was right in his analysis of the legal structure, where he says as part of his judgment, in essence, you can always remove, Section 168 can always be removed and can't be excluded, and all that follows from it are consequences for unfair prejudice. I mean, he's wrong in that, isn't he?
Well, he should have said, well, of course, he could have applied for an injunction to stop it, which I accept. He could have done, but I maintain my submission that he would never have gotten an injunction. There's a case in the Court of Appeal, Pringle and Callard.
Okay, but don't get hung up on whether on these facts. If Dr. Sachs had applied, he could have prevented it or not. That's not the question. The question is whether the judge has got the right legal framework in fitting clause 4.2 into the right relationship with section 168.
Well, he should, I accept, have qualified his statement by saying subject to the right of Dr. Sachs or the minorities to apply for an injunction to stop him being removed. But that doesn't affect it because he would have to make exactly the same qualification for the purposes of if the entrenchment had arisen out of equitable considerations. But nevertheless, it's quite clear from Ibrahimi that notwithstanding the right of the quasi-partner in the Ibrahimi type of case to apply for an injunction, it is still unfairly prejudicial to remove it if it is in breach of the understandings of the parties. So it doesn't make any difference. If my lord sees the point I'm making. And I'm certainly taking my lords, my lady, to Lord Hoffman in O'Neill and Phillips, where he gives the classic discursive treatment of the way in which equity has developed.
Well, you just don't. What I can't really understand why you keep going back to equity. You don't need equity if you're right on the contract, and if you're wrong on the contract, equity doesn't help you.
No, but then Lord Hoffman makes the critical point at the end of the passage, which we highlight in our skeleton argument, that in civil law systems, the same result is applied by applying the doctrine of good faith. So what we're doing is, what we're saying is we're not relying on equitable considerations because we have the duty of good faith. And it's the duty of good faith which brings in train exactly the same understandings that equity gives effect to in its equitable jurisdiction.
No, go on.
Is that right?
My lady.
Is that right? Is there any authority to that effect?
Yes, it's O'Neill and
It's a
Phillips.
very broad statement. You say that an express good faith clause equates to, in all material respects, a fiduciary duty.
Not necessarily, but it can. The authority that we particularly rely upon is Lord Hoffman's speech in O'Neill and Phillips, which can be found.
As my Lord Justice Newey said, I don't want to.
No,
Yeah,
I will definitely come to
That's
that.
your headline position.
Yes, exactly. That's what I'm doing. I'm giving headline positions. We refer to it in our skeleton argument for my lady's note, at paragraph 25, which is page 68 to 69 of the core bundle.
Thank you.
And just for your heads up, when you get to O'Neill and Phillips, you'll have to explain why the proposition you've just outlined is correct in circumstances where the express terms of the contract exclude partnership and exclude fiduciary duties, where those were the bases on which Lord Hoffman talked about equitable restraint, i.e. that company law is derived from partnership, and to put a label on it, the sort of considerations you've been talking about arise in relation to quasi-partnership companies, of which this was not one.
No.
So that's...
I'll deal with that.
You're going to have to deal with those points.
Yep. Now, so headline point still. I will then deal with the authorities dealing with the content of a duty of good faith and the several aspects of a duty of good faith. The judge held that there were 4 aspects which are related but distinct. At paragraphs, he accepted Judge Klein's analysis at 367 to 368 paragraphs, and he repeated that at paragraph 40 of his judgment. There were 4 aspects to it. 1, management by the board. 2, entrenchment of the positions of Sachs and Faulkner. 3, the investors should not have total control. And 4, the duty to consult. There should be a duty to consult over replacement for Sachs and Faulkner. I've jumped forward. There are the several aspects of the good faith.
I missed your paragraph reference there. It's 3.
It's the several aspects of the obligation of good faith are to be found in the judgment at 367 to 368.
367.
And at 400.
Yes, I think.
And now I'm jumping on to a new headline point.
Yeah.
If the judge was right as to what the aspects of the duty of good faith were, what was the agreed common purpose? And there, in my respectful submission, the judge found, on a proper analysis of his judgment, 4 things. And here I'm repeating myself. Management by the board, entrenchment of the positions of Sachs and Faulkner. 3, investors should not have total control. And 4, there was a duty to consult and to offer the minorities replacements for Sachs and Faulkner if they if they went for whatever reason. And then I will deal with the difficult question, which it's difficult to deal with, is what if this court disagrees with aspects of the judge's conclusion? Now, it's difficult to deal with that aspect because we don't know the respects in which you will disagree and to what extent you'll disagree. But I want to focus on one particular aspect which you might disagree with, and that is whether the positions of Sachs and Faulkner were entrenched. So I will deal with that. To what extent should the findings of unfair prejudice that the judge makes stand if he was wrong on the entrenchment of Sachs and Faulkner? I think if I try to anticipate other respects in which this court may differ with him, I'll never end. So, and I don't think that would be a fruitful exercise. But identifying one aspect in which you may be against us, namely the entrenchment of the positions of Sachs and Faulkner, should you nevertheless, or should you strike down all the other findings on the basis that the learned friend says that they will ultimately depend on it? We say they do not depend on it. Superficially, they may be, on the face of the judgment, there may be some infection because of the language he uses, and that on one reading it might be taken that he was relying upon the totality of the agreed common purpose. But we say that would be a wrong way of looking at it. You should look at the facts. You should look at the obligations entailed by the good faith clause and the other clauses in the Constitution, and ask yourselves whether the findings should stand nevertheless. And the last thing I think any party wants in this case is that you should send it back for a retrial. In our respectful submission, this is a case where the court just has to form a view as to whether unfair prejudice has been established and what the relief should be, rather than sending it back to be retried on the basis that the duties were somewhat different to what the judge found. So I intend to follow in my roadmap terms. I'll deal with 2 little Roman 1 and 2 first, which is the Constitution. In other words, the express terms of the Constitution, and the context or the factual matrix. And I do that for a specific purpose, because I then want to deal with number 1 of my roadmap, which is what the judge found, by way of, if we would summarize as the usurpation of the board by the investors. So you can see why the investors ignored the Constitution, regardless of its finer meaning. Then I'll go on to the roadmap 2, little Roman 3 and 4, which will be aspects of the good faith in clause 4.2, which will be the authorities on the meaning of a good faith clause. And then little Roman 4, what was the agreed common purpose in this case, if the good faith clause did require regard and observance of the agreed common purpose. I will then deal with roadmap 3, which is findings of unfair prejudice, and I expect I'll deal that together with 5, which is what difference does it make if the judge's conclusion that Sachs and Faulkner could not be removed is not upheld. And then I will deal with roadmap number 4, which is dealing with specific arguments raised by the appellants. Some of those arguments have fallen by the wayside, and I'll have to deal with a number of points that have arisen during oral submissions. And then finally, I'll deal with 6 and 7, respondents' notice and conclusions. I don't anticipate, I may be wrong, I don't anticipate spending very long on the respondent's notice. Beginning with the constitutional provisions in this case, if you would turn to the Shareholders Agreement and the Articles of Association, these are at Core Bundle 2. If one starts at Core Bundle 2, tab 20, the provisions that the judge referred to, he referred first at, I don't ask you to go with this, to paragraph 68, he referred to the Table A articles. Malone Fenn took you to the Table A articles, in particular Regulation 70, which is that the business of the company should be managed by the board. 80. It says 70.
70 or 70?
We went to 70 and 80. Yeah, yes. 70 is the one that says the management of the business shall be vested in the board, which the judge must have had firmly in mind, and he refers to the Table A articles. It's the most basic principle of company law. It's very difficult to think of a company whose business is not managed by the board. What is unusual about this company, so far as the management by the board is concerned, is if one turns to page 544, (5.1), a provision referred to by the judge, the second sentence, the shareholders shall each cooperate with the board in the running and operation of the company and each CPG group company. Now that is a highly, in my respectful submission, unusual provision, which the judge was right to regard as supporting his finding, which he made at paragraphs 387 to 389 of his judgment, that the business of the company was to be managed by the board, not by the shareholders. He then referred
so you're saying that overrides the power of the majority shareholders by special resolution to direct the board as to any particular power of management? I mean, starting with Article... Can you just give me the reference to the articles, the Table A articles?
Table A articles are in 762, authority 7, tab 62, page 2413.
So the general principle of company law is, if you adopt Table A articles, that the board manages the affairs of the company.
Subject to a special
resolution. Which the directors can, which the shareholders can pass. Sorry, I'm just looking at. Sorry, it was 70. I said 18. It was 70. I'm sorry.
No.
So, all right, yeah. Are you saying that that's no longer operative because of the second sentence of 5.1?
Well,
so
my main submission
the board say we want to buy a widget.
Yes.
Shareholders could say by special resolution, do not buy widget. Are you saying because of the second sentence of 5.1, they are disabled from so doing?
Well, there's a tension between the two, which in my respectful submission supports the judge's conclusion that taking the Table A and the constitutional documents here, the agreed common purpose disclosed in these agreements was that the business should be managed by the board and not the shareholders. So, in answer to my Lord's question, I think I don't need to go that far, but if necessary, I do go that far and say that given 5.1, it was not open to the shareholders to step in and tell the board what to do.
On anything? Or just the running and operation of the company? I mean, running an operation is day-to-day management, is it, or what?
It is. It's very wide. It's everything involved in the management of the affairs of the company. It's coterminous with Regulation 70.
This is all in the context of the business as defined, isn't it?
I don't think there's, yes, it shall be called, the only business be the business, shall probably be the running, well, it's not the running of the business, it's the running operation of the company and each CPG group company. So it's not limited to it's not limited in the way that Malone Friend sought to limit 5.2, which
you're coming to,
coming to, yeah.
So you say the second sentence of 5.1 is not limited to the business as defined, capital B, but even if it was, you say it effectively supplants Article 70, which means basically it takes control or the ability to exercise any control of what this company does out of the hands of the majority shareholders.
Yes.
That's
yes.
Very, very fundamental bit of heavy lifting done by that sentence, isn't it?
Well, no, with respect, it's well. But one has to look at all these provisions in the round and decide: are these very unusual provisions, which can only have had an unexpressed but nevertheless agreed common purpose? Now that's one of them that the judge relies on, and that we say he was right to rely on.
Did he explain how, and if at all, it supplanted Article 7?
No, he didn't. He didn't deal with that issue. It may be as well in this context to go to what the way in which the judge dealt with it, which I think your lordships will find beginning at 386. That's paragraph 386, page 166. Well, just to put it all in context, well, just to put the whole 384, paragraph 384, page 165, he deals with the context. And since we're here at the moment, I invite your lordships and my lady to read the context, but you've read it.
We have read it.
Yes. And can I just draw to your attention Little Roman 4, which is a reference back to paragraph 42. So at the time of the 2010 agreement, although there was no obligation to continue funding, the parties must have anticipated the likelihood that if it were not, in other words, it had not reached break-even, then further capital injection from Vollin might be needed, or there was no obligation on Vollin to supply them. So there was a risk that Vollin would provide further funding and therefore would become ultimately and quite quickly the majority shareholder, which, as the judge points out in paragraph 42, it in fact did. That is in fact what happened. That before the 2013 agreement was entered into, Vollin had already become the majority shareholder because there had been further calls for funding. But anyway, that's the context. Then 385, he says it was a compromise designed to hold a balance between these potentially differing sets of interests, and we rely upon everything that the judge says by way of the factual matrix, which wasn't, so far as I recall, the subject matter of any criticism by my learned friend. But no doubt he would say that it was inferentially or indirectly the subject of criticism by him because of other submissions that he made.
I don't know. Is there any aspect of this that you would expect Mr. Gledhill to disagree with? I mean, 384.
Well, yes, he was disagree with Little Roman 1.
Really?
Little Roman 2, the
Well, it's on Little Roman 1. What was wrong? Why would Mr. Gledhill disagree with Little Roman 1?
The future was uncertain.
I'm not sure anybody suggests the future was certain.
The parties envisaged a potentially long-term arrangement, which in the light of it was likely to become subject to pressures over time. And then he accepted Mr. Faulkner's evidence that Dr. Sachs was the jockey they were backing. That's a reference back, which he picks up again at paragraph 415.
I mean, I'd be a bit surprised if Mr. Gledhill thought he could quarrel with any of this.
So, well, in which case it's common ground that these were relevant parts of the factual matrix underlying the Constitution, and then the judge goes on. 385, no doubt, we respectfully submit the judge was right to come to that conclusion. That if you look at that factual matrix, the agreements were a compromise designed to hold a balance between potentially different sets of interests. And then at 386, he says, your Lordship has already read that, but it leads on to, ultimately, and I think your Lordship's already been taken to this several times by my learned friend, but it leads on to 390, where he summarises it. Thus, the overall structure is clear. The business of CP agencies was to be managed by the board.
And you say that the finding at the end of 390 is that the shareholders had no ability to direct the board under Article 70. In other words, he calls it free from shareholder interference.
Yes. And he cites, he relies upon clause 5.1, that second sentence.
Yep, no, I see that.
389.
And moreover, despite the reference, as we see in 3866, to the possibility of ceasing to be a director by virtue of a provision of the 2006 Act, and
yes,
specifically Section 168.
Yes.
That was not to be invoked.
That was not to be invoked, or if it were invoked, the minorities would be offered replacements.
Well, if it was to be invoked, where is any provision for replacement?
Well, that is part of the agreed common purpose. That,
well, I mean, is there any clause, which deals with the question of what happens if, say, Dr. Sachs dies?
No, there is no clause conferring on the minorities a right to appoint directors. But the reason for that is quite understandable. That the minorities are not a homogeneous class, unlike the investors. The investors are a homogeneous class. They are a group of Russians who Mr. Abramov, Dr. Is it Dr. or Mr. Abramov? Dr. Frolov. Dr. Abramov and Dr. Frolov were close business associates through the flotation of Ezra. And indeed that's why Mr. Abramovich came in as an associate of them, who had also been involved in the Evraz flotation. So they were a distinct class of shareholders. The minority shareholders weren't a homogeneous group at all. It wouldn't have made sense to confer upon them as a class the right to appoint directors, because they were...
Well, how does this constitutional balance that the judge refers to, how is it given effect to that in a situation where, for example, Dr. Sachs dies?
What should happen is the minority should be offered a replacement. That's...
But there you are treating them as a class.
Yeah, where do we get that from?
Well, I get that from all the terms of the shareholders agreement. In particular,
Are you implying a term now, or are you interpreting a provision of the documents we're looking at? If you're implying a term, do you accept you'd have to comply with the Marks and Spencer's test as opposed to Belize Telecom? And if you are, in any event, trying to imply a term or interpreting a term, which terms are you relying on to get us there?
The principal terms are, we're in the shareholders agreement, 7.8, which is at page 5.
Maybe we should take a list from you and then break for
Well, I
lunch.
see the
Or
term.
alternatively, would it be
Yes.
more convenient to break now and come back?
I'd be happy to break now and come back at 2 o'clock.
Well, let's do that. But can we leave it on the basis you will come back with an answer to Lord Justice Snowden's point?
I will. Thank you.
All rise. Put the light, Jason.